Hello everyone, I'm back with Sol Millin at the Gloucester channel. Sol, what I'd like to talk to you about now is a pending matter you have in the HCA, the High Court of Australia, pertaining to the coronavirus. This is quite an important matter. This has the potential to really change the way the public are being treated during this so-called pandemic. Can you give us a bit of detail about the court case? I know you may not be able to divulge absolutely everything, but can you give the listeners and viewers some information?
Well, certainly. It is a public case, and that's the difference in the High Court, that, you know, most of those matters are public. It's a very humorous story because, as you may know, I was arrested for creating protests and divulging an interview with the police, and certain, times were set in the Melbourne Magistrates Court for me to be heard. And before that, I met this wonderful woman called Jackie Dundee, who I met on the 10th of May. There was a protest outside Parliament House, and we just became so close, right? And we worked together, and she introduced me to some guys who liked to be anonymous, right? Who were utterly brilliant in constitutional law. And so they taught me heaps of stuff, right? So we had all these meetings. We produced these cases. We did two cases. Millin, that's me, as a plaintiff. Oh, by the way, I'm an aged pensioner, so I get the High Court for nothing, which is just brilliant because it costs $1 million to get in the High Court, right? So the first case was Millin versus Victoria, and that was developed and put into the court. It was actually, the term is filed. First you lodge your papers, and then they get rejected, and finally they filed. And so that was filed, and it was actually heard, that one. But the second case relates to Clive Palmer, and many people believe that Clive Palmer versus WA, Clive lost. That's the general, thought pattern of people, right? But it's a very complex case, and it brought up an amazingly interesting point, is that in the judges summing up, they said, not much about the Constitution, but they said because there's an emergency, they can close the borders, right? So it showed that the actual crux of the legal argument is the emergency. And so when I went to the Magistrates Court, I'd been clued up by these marvellous people to ask. You start in saying, Your Honour, may I address the court? And then you say, Your Honour, I've chosen to have a constitutional defence, and under Section 40 of the Judiciary Act of 1903, I can apply to the High Court to remove questions of law to the High Court. And in essence, the Magistrates Court accepted that, right? So instantly, this matter went from the Magistrates Court right up to the High Court, right?
Which of course in Australia is the highest court in the land.
Yes. So that was a bit of a miracle, right? Then the Victorian government decided that they were going to fight it for, it was against a particular policeman. The plaintiff was a, policeman, but the counsel for the plaintiff became the Victorian government, right, at the very highest level. And they wrote what's called a response. And they, trashed whatever I'd said and whatever. But in the middle of their response, they said there are no facts. And this was the piece de resistance, right? Because we had independently put together questions of fact, and they proved that this COVID is absolute rubbish, right? And so I did a reply which I was limited to 5 pages, and just threw all these facts at the Victorian government, and in essence said to them, if there's an emergency, prove it. And they can't. They can't prove there's an emergency because there's no science, there's no statistics. And previously I'd asked for an FOI. You know, in the Public Health and Wellbeing Act in Victoria, they have a little section where they have to write down why there's an emergency. It's a very small section, right? So I did an FOI. They refused to tell us. And so that was due on the 22nd of April. And I objected, and I sent an ombudsman requests and so on. And just today, I've got a message back from them saying, "Oh, Mr. Millin, your question is too complex. We cannot process this." Absolute, total rubbish. You know, it's a very clear and very simple question. What are your reasons for an emergency? It's as simple as that. So they're playing games, right, as far as I'm concerned. And I think the High Court knows that this case is very, very important, but they've sat on the case now for 6 weeks. It's been in the High Court for 6 weeks. So it's got on the one side the questions of law, which says the Victorian government's breaking the Constitution, and it's got on the other side the question of facts, which says there is no emergency. If you think there's an emergency, prove it.
What do you think will be the likely time frame before there is an outcome on this court case? I know the matter is still proceeding, albeit from what you've said, proceeding rather slowly. There may be some delaying tactics or stalling tactics on the part of the government because they're fearful of what the outcome might be. Can you give us a bit of a time frame on what you think may unfold?
It's very uncertain, and the reason it's uncertain because it's so important and it's so embarrassing. It's if I was a High Court judge, I would be in a hard place, right? Because suppose that this guy who's saying prove there's an emergency is right, and there is no emergency. It just trashes the whole Australian government. They spent over $3,000 million on this COVID poison, this emergency, medical procedure, which isn't a vaccine, and they're killing everybody and they're maiming people. And there's this old fellow saying, "There's no emergency. You've just wasted $3,000 million." And so it's a terribly hard decision for the High Court to make. So I tried to make it easier for them, and I invoked what's called Section 80 of the Constitution, which says that if there's an indictment against an overthrow of the Constitution, it should be trial by jury. You read Section 80 of the Constitution. Silence, absolute silence on the High Court. Nothing. I tried to invoke what's called a mandamus, because they all speak Latin in law. Mandamus means an order against a lower court or person. And because they're not giving the FOI information, I thought the High Court could issue a mandamus. The High Court says, no, we won't. And my reading of the Constitution and of the High Court rules says they have every right to issue a mandamus against the Victorian government. So, I think it's just shockingly embarrassing for the High Court. And as to the outcome, I have no idea. That's why I'm becoming vocal now, because when you go to the High Court and you can't get any response, what do? You have to become vocal, don't you?
Well, as you are probably no doubt aware, I was in Melbourne recently, and I think I'll be going back there because there are some important developments going on there, and your court case is certainly one of them. So this is all just adding to my reasons to want to go back to Melbourne. At some point, I'm sure you'll be back there. We've got a bit of time to wait and see how things unfold before we can give the viewers and listeners a bit more detail on this case. But It's one that's well worth watching. So, Saul, if it's okay with you, we will be revisiting this topic sometime shortly.
Okay.